Plea in mitigation. What exactly is plea in mitigation? Plea in mitigation means the submissions made by the defendant or their legal representative as part of the sentencing process, whereby they present the information, evidence which they rely on to reduce their role in the offense, so that the judge can take this into account in sentencing. The aim of this video is to look at a hypothetical plea in mitigation question and try to provide solution to the question at hand. Question: you are instructed to prepare an oral plea in mitigation for sentencing on behalf of a defendant in a Crown Court. Facts: the defendant, Mr. A, aged 37, has pleaded guilty to one count of robbery under Section 8 of the Theft Act 1968. On 15 August 2025, Mr. A approached a pedestrian in a public park in broad daylight, demanded the victim's mobile phone, and threatened to punch him if he did not comply. The victim handed over the phone. Mr. A has no previous convictions. He is the primary carer for his 8-year-old son who has a diagnosed anxiety disorder and requires daily supervision. Mr. A was under significant financial pressure after losing his job 3 months earlier due to company redundancies. He has expressed remorse and pleaded guilty at the first reasonable opportunity. A pre-sentence report, PSR, notes that Mr. A has secured part-time employment with a local charity while on bail and has engaged voluntarily with counseling services for anger and stress management. Task: prepare a 5-minute oral plea in mitigation for Mr. A. You should address the following. A. Relevant mitigation factors. B. Sentencing purposes and principles. C. Statutory factors and guideline considerations. D. Why a custodial term at the lower end or a non-custodial disposal, if appropriate, is justified. You may assume all relevant victim personal statements and probation information are available. Now let's provide a hypothetical plea mitigation answer. May it please your honor, I, Adesiri Eno, appear on behalf of Mr. A, who stands before the court having entered a guilty plea at the first reasonable opportunity to one count of robbery. He accepts full responsibility for this offense and offers no excuse for his conduct. Your Honor, the question before the court today is not whether punishment should be imposed, but rather what form of punishment is most appropriate. One that is proportionate, carefully tailored to the individual, and consistent with the forward-looking principles set out in Section 57 of the Sentencing Act 2020. Your Honor, I will address mitigation under 8 brief but important headings. 1. Early guilty plea. Your Honor will be aware that the defendant entered a guilty plea at the first reasonable opportunity. That plea was not tactical. It was entered because he accepted wrongdoing from the outset and wished to spare the complainant the burden of a contested trial. He therefore attracts a full one-third reduction under the Sentencing Council guideline, which I respectfully invite the courts to apply in full. 2. Genuine remorse. Your Honor, this is not a case of formulaic regret. The pre-sentence report records consistent expression of remorse, insight into the harm caused, and an understanding of the wider consequences of his actions. Importantly, Your Honor, remorse here is demonstrated by conduct and not by mere words alone. Cooperation with the police, compliance with bail, and engagement with probation from the earliest stage. 3. Previous good character. Your Honor, this offense stands in complete isolation. The defendant has no previous convictions, cautions, or reprimands. He has lived a law-abiding life and is not someone for whom the criminal courts are familiar territory. That matters, Your Honor, because first-time offending is a reliable indicator of low risk of reoffending, particularly where responsibility has been accepted early. 4. Personal circumstances. The court has read of the defendant's personal background. He is in stable employment, supports his household, and plays an active role in the care of his family. Imprisonment would not punish him alone, it would create collateral harm to those who are entirely innocent and dependent upon him. A factor the Court of Appeal has repeatedly recognized as relevant where the impact would be exceptional. 5. Impact of custody. Even a short custodial sentence would have disproportionate consequences in this case. Loss of employment would be immediate. Housing would be placed at risk. Any rehabilitative progress would be interrupted rather than advanced. Your Honor is not asked to treat those consequences as a shield from punishment, but as part of the overall proportionality assessment. 6. Rehabilitation and low risk. The pre-sentence report assesses the defendant as low risk of reoffending and suitable for community-based intervention. He has already taken steps to address the causes of this offense, demonstrating that rehabilitation is not a future aspiration, but a current reality. This is precisely the category of offender for whom the court can be confident that supervision works. 6. Public interest and sentencing purposes. Punishment must, of course, mark the seriousness of the offense. But Your Honor is equally required to consider rehabilitation and the protection of the public. In this case, the public is best protected not by removing a first-time offender from society, but by ensuring that he remains accountable, supervised, and productive rather than destabilized. Final submission on disposal. Taking these matters together, the early plea, genuine remorse, and clear rehabilitative prospects, previous good character, strong personal mitigation, I respectfully submit that immediate custody is not necessary to meet the statutory purposes of sentences. I therefore invite your honor to consider whether a community-based disposal, properly structured and punitive, would better reflect proportionality while still marking the seriousness of the offense. Unless I can assist the court further, those are my submissions.